Hello, good evening, good morning, good day to everyone. So I'm just setting up my social media platforms. Can you give me a feedback if I sound okay, please? Shout out to Sir Philip and si Ma'am Manilin. Yan, niloloko mo lagi si Ma'am Manilin, sir. Okay, thank you. Odag Reen Mordago. Okay, so maraming nagre-request dito that I'm gonna talk about again any update on the J1 visa waivers. Every time na magla-live ako, there's always a question about waivers. So then this is your opportunity now. Okay, just give me about 2 minutes to set up my social media platform, and we should be okay. So medyo I prepared about 19 slides and I should be able to actually talk briefly about the slides, but I know na maraming mga tanong. So again, I'm putting this opportunity to all of you to ask questions about the J1 waivers. So just very quickly, again, good evening in the United States. Magandang umaga in the Philippines, and then good day to everybody anywhere in the world who are actually interested to know about J1 waivers. And then, so since the topic is about waivers today, I just want to give a shout out to my waivers team in my Davao office, headed by Thea Cabillo and her team, Angel and Tracy. And also in my team here in New York, JT and Jetro. So again, thank you guys for all your support. You've been very helpful with regards to giving a best argument in our cases. So again, thank you very much. So then I'm now ready to start my presentation. So just use as usual, I'm gonna put my slides here at the background so you could actually follow me through with my topics. And kung may mga tanong kayo, ilagay nyo lang sa baba sa comment section and I'll try to answer them as soon as I can. So this is the J1 visa waivers for those who didn't know. So if you actually had signed up or you are currently on a J1 visa or you are still waiting for your J1 interview at the embassy, you're hoping that you will not be subject to the 212E, but most of the time you will be. And at least alam mo yung mga options nyo ngayon that if you happen to be subject to the 212E, then what can you do to plan ahead? So when you actually sign up that agreement that you'll be entering the US or you already had entered the United States on a J1 visa and you are subject to the 212E that you're going to go home when your program ends. Initially, it is for 3 years, but you could actually stay here maximum of 5 years depending on whether or not your employers would want to actually extend. But if you cannot obtain a waiver, then you have to go home and spend 2 years outside the United States before you can come back. Okay? So I'll be sharing, but again, before everything else, I'm gonna put a disclaimer that joining this Facebook Live does not create an attorney-client relationship. So even if I'm gonna answer your question, generally speaking, don't take it as a legal advice. If you would want to get a formal opinion, then I would recommend that you consult with an immigration attorney so you'd be guided accordingly. Again, don't take this Facebook Live then as a replacement of you having a formal consultation with any immigration attorney of your choice. Hello, Ma'am Elaine. Kumusta po? So, this is the legal basis of what the INA 212E, so this is the Immigration Nationality Act, that says no person shall be eligible to apply for an immigrant visa or permanent green card or other non-immigrant visa until it is established that such person has actually stayed or physically present outside the United States, either in their home country or the last country of residence for at least 2 years following their departure in the United States. So again, summarize ko na, if we will be talking about in general terms J1 visa holders. But whatever we discuss here, kung may mga restriction man ang J1 visa and your J2 dependents, whether it's J2 spouse or children, such restriction also applies to them. So pareho lang yun, no? So then we're gonna talk about the basis of the waivers. So there are two actually sources that we're gonna talk about today. The first one is the Department of State basis of waivers, and there's about five. So the common one is the no objection statement, the no objection statement, or commonly known as the NOS, which applicants normally apply with their home country government. In our case, for Filipinos, it's in the EVP, the exchange visitor program of office in Manila. That's how you're going to submit your no objection statement applications. And then for the first time, and this is like a very good development, that finally the Bureau of Indian Education is now facilitating or accommodating interest IJA waivers. This is the Interested Federal Government Agency waivers. And we're going to talk about that. This is an exciting development kasi mayroon namang additional source yung mga J1 teachers natin who are subject to the 212E to apply for a waiver. Then persecution. So those ones that I actually highlighted green are the ones that we will be talking about for purposes of this presentation. And then the second common waiver is the exceptional hardship. So again, the exceptional hardship generally is used for people who are married to a U.S. citizen or a green card holder or who actually have a U.S. citizen child. So yun yung basihan nila. And then we'll talk about very quickly the Philippines no objection statement. And again, this is facilitated by the EVP in Manila, and I will be sharing with you the latest resolution as of April 6, 2021. And this is also the same version that the website of the Philippine Consulate here in New York is actually publishing. So again, those are actually aligned with the latest resolution or guidelines they have for the J1 visa holders. So there's the basis for the no objection statement, and it actually says that the ABP is willing or will review or consider applications, those no objection statement with highly meritorious cases, including but not limited to research or studies or any professionals whose continued presence in the United States will be beneficial to the Philippines' national interests. So as we go through this one, don't ask me about, okay, can you give me examples of research and studies? Because even the guidelines did not really uh, specify examples of these waivers. What it actually says is a general framework or guideline saying that if you have an idea or if you are conducting any research or projects currently now in the United States, and if you believe that that would be beneficial to the Philippine government. So, and again, since we are talking about the teachers group here, you're talking about if it is whatever you're doing, if it is beneficial to the implementation of any program in the Philippines or any quality, improving the quality of teaching teaching in the Philippines, both in the elementary and high school levels, then give it a try. No, since there is no specific requirement, there is no specific format, then might as well present it to the EVP. Who knows if they will actually give that a consideration. But there are some specific guidelines, though, that you actually could use at least to assess if it's worth it. So, ang sinasabi lang niya, yung researches and studies mo should be sustainable and should be suitable to, again, to the current priorities of the Philippine government. So, what it meant is, kahit wala namang actual implementation yung studies mo, but if you believe that once given the opportunity to implement that, magiging sustainable siya or doable siya, they might as well submit it to the EVP, and who knows, they will actually consider that. And then it also should include detailed research, no, including implementation plans or paano ba natin gawin to para ma-assess natin yung practicability of implementation or doability once the EVP decides to adopt those recommendations. The guidelines also says that if the applicant, so kunwari, may mga cases kasi tayo na kagaya ng sinasabi ko, initially you will be given a 3-year J1 visa validity, and then you could basically extend that to 5 years. But there are cases, unfortunately, where an applicant will not be able to complete the program. So, halimbawa, some of them actually get a 1-year validity, and for whatever reason, 1 month later, 2 months later, from arrival in the United States, they decide to go home, or hindi nila tinapos yung 3-year term nila, or the 2-year extension on the fourth and the fifth year, then they cannot apply for the waiver. But that there are exceptions to that, though. Number one, if halimbawa, there are three parties of a J1 program, right? The J1 sponsor, the training institution, and you being the teacher, applicant, employee. So kung kunwari, the reason why you did not complete your program is the training institution or the J1 sponsor has violated your rights, then you will be excused from that exemption. It means that you can apply for a waiver. Or if the J1 sponsor or your employer has canceled, suspended, or terminated your program without your fault, then you could still apply for a waiver. No. So what I actually noticed based on the recent guidelines is tinanggal nila yung requirement na you have to have a US citizen child, or you are married to a US citizen or a green card holder to be able to apply through the no objection statement. So it doesn't seem to be na may requirement pang ganon. So that's a good news kasi yung mga wala ng ability to manganak ng US citizen, or wala ng opportunity na makahanap or mapangasawa ang US citizen or green card holder because they are already married, then there seems to be no such requirement anymore, for as long as your research or studies would be beneficial to the national interest of the Philippine government, then you might have a chance to get an approval of a waiver. So again, that's the good development there. Ang hindi lang talaga klaro is ano ba talaga, how does the research or the studies look like. But again, generally speaking, kung mayroon kayong mga studies or projects that you are currently managing in your schools now, might as well present it to the AVP. Malay mo, magustuhan siya, then they might approve your nako, si Ma'am Manilin. Bakit ngayon lang daw? Yun yung problema natin, no? So, again, this is actually what we call, even in the US immigration cases or cases in general, there are people whose cases will be safe because there's a favorable change in immigration law or regulation or requirement or procedure. And it happened to be that this is actually the latest development they have. So, again, even if you are um, already in the Philippines, I mean, there's a requirement that you have to be here. Matagal din kasi yung processing time, no? So again, don't ask me about the details of this. Hindi naman ako talking on behalf of the EVP. I'm just actually sharing their guidelines. So I have a question here, though. Ask ko lang po, if yung US citizen child, if a dual citizen ko, maka-affect po ba pag nag-apply ng exceptional hardship? No. You could basically, it doesn't matter if you will apply for dual citizenship, you still have a ground for exceptional hardship waiver. The EVP says also that they cannot they will deny an application if may utang kayo, either with the Philippine government or any private institution in the Philippines. So as a matter of fact, it's a requirement when you actually apply initially for your J1, or if you apply for your renewal, na dapat meron kayong certification na wala kayong utang in the Philippines. Or if you actually submitted an incomplete application, or if you actually have submitted fraud or mga falsified documents, then they will basically deny your applications. Eileen, bawal po ba magpakasal sa US citizen? I'm planning to get married to an American boyfriend this December. I am on my 3rd year of J1 visa. I am just worried that my sponsor visa will terminate my program after getting married. So I understand where you're coming from, Eileen, though, because most contracts between you and the J1 sponsor specifies that if you are married to a US citizen or green card holder, that J1 sponsor may cancel your J1 program. And again, that's a standard provision in their contract. If the question is bawal bang magpakasal, of course, hindi siya bawal, no? Because that's your basically constitutional right to get married, no? But generally speaking, they put that in the provision, but I haven't seen any J1 sponsor aggressively implementing that. But the moment you are applying for the waiver based on the marriage to a U.S. citizen, then they may cancel your visa. And again, I would recommend that you would consult with an immigration attorney to actually get better guidance as to, okay, if you're now getting married, you're in your third year, when will you be able to apply for a waiver? Or kung mas maganda ba na mag-apply ka na lang muna ng 2 years mo na extension before you would even consider applying for a waiver. But hindi siya bawal, no? You can get married. Kahit nasa Pinas na attorney, gumawa ng research para mas shorten yung time ng 2 years. So again, the context of these EVP guidelines though is you are conducting research studies in the United States, right? Kasi pag if you would be able to actually see that, hey, this is the J1 visa is an exchange visitor visa, and the context that they are actually considering when they actually draft the regulation is you are currently in the United States, you actually had an idea and you pursue with a study or a project, and you think that with the implementation or even in the implementation stage or in the idea pa lang, no, sa implementation plans mo, you think that it would be beneficial to the Philippines, then you would want to use that as a basis for you applying for a waiver. So in the context of question mo, if you're already in the Philippines, so ano bang consideration nun? Ang research mo ba, project mo ba is in the context in the Philippine setting and then you're planning to use it in the US? Or is that an idea coming from while you are in the US but you are not able to complete that because naubos na yung time mo, and now you are back in the Philippines and you're just trying to complete that. So if that is the pattern that you are looking at, it could have been a lot better, or you have a better chance of approval na while you were in the United States, you had applied for the waiver through the NOS. Kasi yun yung pinaka-consideration nila na they will grant you waiver and they have seen a merit in your project or research, and you going home will actually be detrimental to for the finalization of your projects or research, no? So you could actually use that as a strong argument na, hey, bigyan mo muna ako ng waiver because if this seems to be successful and I would be able to go back to the Philippines and stay for 40 hours training the other beneficiaries back in the Philippines. On average, how long did it take for most of the J1 teacher clients to wait? So unfortunately now, even if you actually look into the published processing times, the exceptional hardship waivers now is taking more than a year. If you've been following me, all the approvals that we actually posted, minimum done 1 year and 3 months. If you actually look into the publishing period, you could actually look at 18 months processing time, and it's really taking time, a lot of time. It used to be 4 to 5, 3 to 6 months before the pandemic, but then the pandemic hit, and it's now taking a lot longer time. Hello, Mark. How's Florida? Okay, thank you for and then we'll continue with the slides then. So, okay, sulat nyo lang yung questions nyo. So, as I actually see them, I'll try to answer them. So then we are still on the no objection statement, no? So sa akin, it is still a very hard path to go through the no objection statement. But if you really have a legitimate meritorious project or studies, actually that actually gives you additional ground to apply for a waiver, because tinanggal nila yon dati kasi you have to have at least a US citizen child, or you are married to a US citizen or a green card holder plus the project, or they really did not look at it that way, but the guidelines sounded that way. But ngayon at least mas klaro na. Hindi na kailangan may anak ka or may asawa kang US citizen before you could apply through the NOS. Lerma, I just want to be clear. Once ba na-approve ang NOS, then na-waive na ang 212, pwede ka na maghanap ulit ng sponsor? Yes. Or ma-extend lang ang stay mo sa US but still under J1 visa. So again, even if you are applying for NOS at na-approve ka and you are currently in the United States, yes, you could basically shift to H1B or to another visa type if that's what you want. para hindi ka na J1 nun. As a matter of fact, upon approval, as soon as USCIS received the favorable recommendation from the Department of State, they will issue you the formal 612 form approval notice. Then they will also notify your J1 sponsor that you are no longer a J1 visa, but is already out of status. That's why once you actually receive a favorable recommendation with the Department of State, I would recommend that you consult or approach your HR or your superintendents right away to initially start your H1B before your service becomes inactive. Because at that point in time, wala ka ng status nun. So when is the best time to apply for a waiver? During the third year or end of second year? This is a very tricky question. I have a slide but I'll answer it anyway. The best time if you are on the third year, initial 3 years, kung sigurado ka sa grounds mo, I would recommend that you apply on the second year. But there is a risk there kasi pag kunwari matagal ang processing ng waiver mo, then you may not be able to apply for the 2-year extension. Or if you're already in the third year, I would recommend to wait for your recommendation, to your 2-year extension before you apply for a waiver then. Mark, what if we already have an employer, sir? Can we continue the H1B or EB3 visa directly? So the best route talaga sa J1 transition after your waiver is H1B. Unless your school already have an approved labor certification, then it will be very hard to get the green card right away because that process could take at least 2 years. So if you are on a J1, then fortunately your waiver is approved, you cannot get a green card right away. So the best way for your employer is to get the H1B first, then apply for the green card later. This one, how about po if the sponsor canceled a visa dahil nagpakasal sa US citizen and at the same time po nagka-process na po yung waiver? Paano ba yun? Is this in context to the interview, I mean, sa question kanina na if you're married, bawal ba magpakasal? So, but I would dissect this question then. How about if the sponsor cancel the visa dahil nagpakasal ka sa US citizen? So, are you asking the question about, can I still apply for the no objection statement even if, balikan ko lang yung slide na yun ha. Because what the NOS now is saying is hindi na niya requirement na you are married to US citizen or a green card holder. Ang sinasabi lang niya, if you have studies or projects that are meritorious, then they might grant you a waiver. Pero hindi ka daw niya i-approve ng waiver kung hindi ka nag-attend. Halimbawa, na-approve yung J1 mo, pumasok ka sa US, but hindi ka sumipot doon sa employer mo. So you really did not show up and continue your J1 visa, then you cannot apply for a waiver. Except if the reason why hindi ka nakapunta doon or hindi ka nakapunta sa employer mo or hindi mo tinapos yung program mo is cancel ng J1 sponsor yung visa mo. So if that is the context that you are actually looking at, it doesn't seem that you fall into the exception though, because the exception says that it is the applicant, no fault to the applicant. But getting married to a US citizen, though hindi naman siya bawal o hindi naman siya kasalanan, but if it is specified in your contract, then you are actually technically breaching your contract. So then they were justified to cancel your J1 visa. So, but then again, it becomes complicated conversation. I would recommend that you consult with an immigration lawyer so you'll be guided accordingly. Shaira, would being married to a citizen and having a house together be enough for a waiver? No. No? So hindi siya enough na nagpakasal ka lang sa US. I mean, if you're looking into the exceptional hardship route, preparing an exceptional hardship is exceptionally hard. No? So ang applications namin, we actually submit 5 inches or 6 inches thick argument for exceptional hardship waiver. So if you're just looking at, okay, maybe having a marriage certificate and proof that you bought a house should be enough, no. It's more than that. So you actually look into the 4 factors that you could actually use as your argument for a stronger waiver. So family ties, economic ties, physical, mental health factors, or the third one is the safety and safety and wellness of the qualifying relative. So again, you get the combination of those four to have a strong argument. But buying a house and to actually show that you are actually paying together the mortgage could actually make your case strong in the economic argument part. But hindi siya, yun, the two factors alone is not enough. In case that we don't have any grounds of a waiver, can we apply for O1 visa to get us more time to work into the US? So if the question is, can you apply from J1 to the O1? And again, assuming that you would qualify for the O1 visa, and again, I didn't have the time to basically prepare my materials for the O1. Yes, you can. But again, at the end of the day, you can only go on an O1 visa basis. Then at one point in time, you would want to become a permanent resident. And even if assuming that after your J1 5 years, you get to work on an O1 for another 5 years, so 10 years na yung stay mo sa US, and then suddenly you get tired of the O1, you would want to be a green card, you will still be confronted with the question, have you already obtained a waiver or have you complied the 2-year home residence requirement? So you are actually just pinatagal mo lang yung paghihintay mo to comply with the 2 years. But to answer the question, can you transition from J to O1? Yes, definitely. Are school district H1B cap exempt? It depends, no? So there are questions about public school systems. Basically, they are three requirements to be cap exempt is that they are part of the non-profit organization, which they are, that they are tax exempt, which they are. The only question is if they have affiliation agreement with a higher institution, college or university, then they would actually make them, it would comply with those three requirements, make the school district H1B cap exempt. Judith, is it possible to process a green card after a J1 program? So then again, the guidelines natin, and I have this several times, and I would really encourage you to follow me on either YouTube or on my TikTok. This question keeps repeating itself, right? And then pabalik-balik siya, and then basic principle lang naman eh. If you're a J1 visa holder and you are subject to the 212E, and that's basically our first slide. Balikan lang natin, no? If you are a J1 visa holder, you are subject to the 212E. You cannot apply for a green card or immigrant visa or change to another non-immigrant visa, particularly the H and the L, if you don't have a waiver or you have not completed the 2-year home residency requirement. So to answer the question is, can we transition from J1 to green card? Well, it depends. If you are not subject to, possibly. If you're subject to, no. Even if you're not subject to, if your employer has not filed the labor certification yet, so then it would still be impossible to jump from J1 to the green card. No? So I hope that would actually give general guidelines for the J1 visa holders. Na kung subject to 1-2 ka and you don't have a waiver, then you're going home for 3 years or 5 years later kung hindi mo itutuloy or i-maximize yung program duration mo sa J1. Granting that my maximum stay here in the US 3 years and 2 years extension are approved, and what if my school is willing to process my H1B? Is there a possibility na hindi na need umuwi? Again, it's the same context, different question, different scenarios. If you are subject to the 212E, you go home unless you have a waiver or you comply with the 2-year home residency requirement. Na-approve ng I-140 ko on June 21 and while waiting for my NOAA for a year, my employer canceled it. Can I still use my I-140 with another school district? There is what we actually call portability ng I-140 or recapture of dates. If the question is, can I still use my I-140? It's already been approved. Well, another new employer will still have to go through the labor certification process, and with the retrogression now, you could still actually take advantage of your earlier priority date. But again, hindi siya yung automatic magagamit yung mga I-140 kasi the I-140 is specific to the employer. But there's a lot of benefits. Kung mayroon ka ng approved I-140, it can be ported to another employer. The other employer could basically take advantage of your earlier priority date. but you still have to go through that labor certification process. Mark, I mean, we are already here in Florida holding a J1 visa. Is it possible to continue or stay here having an employer who will sponsor me? Although my visa is only until July, or is okay. So if you are a J1 visa holder and you are actually given initial 3 years and then na-approve yung 2 years mo, you don't have to go out to the country to prove that you are lawfully present in the US. You only need the new DS 2019 that actually shows an extended period for another 1 year or 2 years, depending on the practice of your school. But there's no need for you to go out to have stamping unless there is really a need for you to go out. Then kailangan mong mag-appear for visa stamping at the embassy to be able to come back to the US. Leda, in case po in the transition sa H1B ng J1 visa na not subject to, okay? School district po, not cap exempt, lateral lang po ba ang way nito? Yeah, so if your school district happens to be not cap exempt, but again, if you are in the public school system, I would recommend that you connect your school to us because they can really be cap exempt. There's a way to convert your school to actually cap exemption. But if you are working in a private school, then it could be a harder situation. No? But then if you're not cap exempt, might as well consider maybe looking for another employer who are cap exempt. So you could convert your J1 to H. Can I change my J1 visa sponsor if our district is able to sponsor J1 visa? Our district has cheaper fee compared to my current visa hold. If the question is, can I change visa sponsor? Yes, but you might be subjected to another 2-year home residency requirement kasi moving to another J1 sponsor means you will be placed into another J1 program. So imbis na 2-year home residency ka lang, then you might be subject to the 4-year home residency requirement because the 2 years is attached to the program. No? So if you're already using two programs, then you might be subjected to the two-year home residency requirement. After the program, Uwing Pinas, can we enter US on another visa? Chance of approval for a tourist? No, not necessarily possible. Unless you already have an approved tourist visa, we've seen cases where hindi kinancel ng embassy yung tourist visa nila and then they get approved with a J1. Then at the end of your J1 visa, you can still use your tourist visa then. But generally speaking, you will not. It will be a hard time. It will be very hard for you to obtain another J1 visa then. What about Tony? What about if you get your FR? Can you spell out what FR means? But you haven't received your waiver. Your favorable recommendation. Okay, so let's just use acronyms now kasi maraming pwedeng maging um, interpretation nun. So if you get your FR but you haven't received your waiver in hand and you have just 30 days before your J1 visa expires, I would recommend that you apply for H1 already. Yeah, if I were you, meron ka ng favorable recommendation, discuss with your HR and or your superintendent to apply for your H1 right away. Is it necessary to finish the 2 year stay sa Pinas or pwedeng makabalik sa USA if my employer agad? Again, if you're subject to the 212E, you need to stay for 2 years. If not, you don't even have to go home. You can change to H1 or another visa type. Public charter school po ang school district na employer ko, LEDA. Okay, so pag chartered kasi, generally speaking, chartered schools are created by virtue of special law. Then we actually look into that. We actually look into the articles or the formation of the charter school, and we actually see if they are actually could pass the H1B cap exemption. So it's not a yes or no answer to your question, Leda. I would really recommend that you reach out to an immigration lawyer to really assess the documentation of your school. So you connect your school and with you to a law office and assess if your school would qualify for H1B cap exemption. Attorney, ask ko lang po, kung public school district lang pwede mag-apply ng waiver for J1 teacher subject to the 212E? No, the J1 visa program is basically available to whether public or private companies. And they could also cover other professions, hindi lang mga teachers, right? So there's a very long list of professional, I mean, skills lists, country skills list that actually mentions a lot of professions or fields that could apply for the J1 visa. So, again, to answer your question, hindi siya limited to public schools lang. Okay, going back to our slides here. Tapos na yung mga EVP and OS ko questions. So, if you're gonna go back sa EVP, I think tatapos na natin yung EVP, no? Then we'll just talk about the BIE because this is very important and this is a very good news to teachers who are actually working or assigned in a tribal schools or tribal regions, and your school is part or under the Bureau of Indian Education. The good news is they are now accepting waivers. For the longest time, we've been negotiating and working and lobbying for the BIE to basically accept waivers, but only recently this year, that early this year, that they actually started accepting that waiver. So the U.S. Department of Education has not accepted waivers yet. I hope they would, because the BIA has already opened their doors for accepting waiver applications. So let's try to understand more of the BIA structure then. So there are 184 elementary and secondary schools and dormitories in the United States. There are 63 year reservations in 23 states. So if you are not so sure if your school is part of the BIE, I would recommend that you ask your HR or superintendent if you are part of the BIE. And if you are, then your school, not you, could basically apply for the IGA, Interested Government Agency waiver through the BIE. And the good news is they are very, very supportive of the waiver application. So that's a good development. So the nature of the IGA waivers, kagaya na sinasabi ko, no? So while when we make arguments of the interested government agency waivers, we still look into the individual circumstances or contributions of the individual applicant to argue that the BIE should grant you waiver. Only the employer can submit that application on your behalf. So hindi pwedeng ikaw yung mag-a-apply. So we've already known that the no objection statement or the exceptional hardship waivers should be filed by the applicant or the teacher themselves. But for IJA, you cannot apply on your own. You really have to ask your HR or superintendent to file on your behalf. So in terms of procedure, I recommend that you consult your HR and superintendent first. And once they are in support of your waiver application, that they will contact the BIE nearest you, and no question, the BIA office will actually tell you, hire a lawyer to help you out so we could actually support your IGA waiver application. So yun yung proseso pagdating sa IGA. Okay? Don't call a law office, don't call us kung hindi nyo pa na-reach out yung BIE. But once you initially have that contact, we could definitely help you with your IGA waivers. B, okay, more questions. Ask ko lang, kung public school district lang, I think I answered the question. Sa Pilipinas po ba mostly subject to the 212E rule? Yeah, generally speaking, because under the country skills list kasi, category 13, education is part of that list. So generally speaking, Filipinos are subject to the 212E. But marami din cases na hindi siya subject. No? Maraming factors doon kino-consider. Funding issues or the nature of the program or the nature of the subject area. SPED in general most likely will become subject to the 212E. But then again, category 13 for the Philippines is education, and they are part of the school skills, the country skills list. Elmer, kung sakali pong nakasal ka sa US citizen at umuwi kayo ng spouse mo sa Pilipinas ng 2 years, anong visa ang i-apply? I would recommend, even after yung 1 year, huwag ka nang mag-waiver. So, pwede nang simula ng asawa mo ang spouse visa. So, you are not actually going back to the US either on an H or a J1 visa, but I might as well your US citizen spouse file the spouse visa for you after 1 year kayong umalis ng US, para the spouse visa will still take about 9 months to 1 year or 1 year and 3 months. So by the time na mayroon ka ng interview sa embassy, you are already ready for, by the time na natapos mo yung 2 year home residency requirement mo, you are already waiting for your embassy interview. So it doesn't matter kung ang asawa mo is nasa Philippines when you file for the spouse visa, it's allowed. So, pwede mong gawin yon to avoid getting another H or J1 sponsor to be able to come back. Ayong gabi, attorney. Ayong gabi sa mga Bisaya, proud Bisaya here. So, kung ang reserve area ay hindi member ng BIE, can they apply for a membership? That I do not know. I would recommend that maybe you would contact the BIE. I don't know what their requirements for them to become, for being part of, but ang alam ko, they are regionally defined, what makes uh, a school part of the BIA. Just like what I actually mentioned a while ago, there are 183 schools and dormitories part of the BIE's system. No? So, again, I cannot answer this question. I would recommend you reach out to the BIA office. I'm very sorry for this statement. However, I do not see the significance or relevance as to why 2-1-P rule is being enforced. Why not just let schools keep their qualified teachers and then work for the legal papers? I know it is the law, but as long as it's legal, bakit need na? So, and unfortunately, and I can share the frustration and so on, but unfortunately, this is not the right forum for that, right? This is what your congressman and senators has approved, and the arguments could have taken place in the floor, the legislative floor, and that's what they've agreed upon. What we are talking about here are basically compliance of the law and talking about possibility of waivers. Gaano po katagal ang pag-process ng IGA? Normally, the guidelines is it would take time preparing kasi hindi siya, when you file for the IGA waiver, there's a lot of supporting documentation on the side of the applicant as well as the employer. And then, once you actually prepare that, then you have to submit it to the BIE, because it's supposed to be prepared by the employers, forwarded to the BIE. And if the BIE is supportive of your application, then they will forward it to the Department of State. In terms of timeline, we are actually looking at 4 to 6 months processing time. So if you could apply for the BIE the sooner time possible, it's better for you. Balikan ko lang yung question kanina, no? Ang problema kasi is the J1 visa is not a solution to the scarcity of teachers in the US. That J1 visa is an exchange visitor program. In the first place, kasalanan din ng school bakit kinuha nila J1 visa, no? Kasi kung talagang ang intention nila is to provide a more established or stabilized organization, they could have hired their foreign teachers on H1B in the first place. But alam natin na very expensive yung H1B over the J1 visa. So they basically had decided to hire on J1. And I believe that you J1 applicants were apprised initially that when you signed the J1 program, that there's a really high possibility that you're going home. That's very clear in the program, in the J1 program. Pwede po ba kayang mag-seminar ng teachers sa Philippines? Kaysa, yung seminar, part na ng ano yun, part na ng, kunwari, na-approve ka ng NOS. So, the EVP would really require you to render 40 hours equivalent of training time as part of your minimum compliance before kanila mabigyan ng waiver. Geds, the BIE approved the waiver. Yeah, that's actually the very good development they have this year. In case po na natapos mo yung 5 years under J1 and nag-exit ka to other countries, di mo serve yung 2 years to your home country, makakapalik po ba sa US? No. And again, ito yung pabalik-balik din na tanong na, okay, I obtained my J1 visa in the Philippines. Then, after my 5 years, I would go back to Canada or Australia for 2 years. Can I get back to the US? No. Going back to my second slide, it actually is very clear. You have to complete your 2-year home residency requirement either to your home country or the country of last residence nung na-obtain mo yung J1 visa mo. So it means you are teaching in Thailand, you obtain your J1 visa in Thailand, then you may have the option of going back to Thailand to complete your 2-year home residence requirement, but not outside those two countries. So either it's your home country or your last country of residence. Kung J1 visa, pwede ba magamit ang approved I-140? Again, you can have your I-140 approved, but if you are subject to the 212E, you cannot use your I-140 because you still have to comply with either the waiver or the 2-year home residency requirement. Main gabi, what is the best year to file for? I will answer that later. So, yung hardship waiver, kailangan kasal ka sa US citizen or may anak. Ano nga po ulit yung reasons under the hardship to make a strong case? So, again, general guidelines lang, there are actually 4 areas that we actually use to argue as or to provide a stronger exceptional hardship argument. So, you have your family ties, your mental or physical health ties or factors. Then you look into your economic ties. And then the fourth one is the security and safety ties. Panga, would it be possible that the school will start the processing of the H-1B papers of the employee on the 4th year of teaching? If you are subject to the 212E, the H-1B can be approved in 2 months. We don't recommend filing your H-1B if you are subject to the 212E. How about non-BIE but teaching large population of Native Americans? Is there a chance to get endorsement? Again, the context is it's the BIE supporting the application. So if your school district is not part of the BIE, then technically you are not part of the BIE program. But then again, I will not stop you from contacting the BIE office and seek guidance if there's a way they can do to help out. So tuloy tayo sa kasi marami ng question about the timing. Okay? And I think I have five slides left. Then I will end the live show. So, kailan daw magpa-file ng kailan ka magpa-file either ng H-1B or your green card application assuming that your waiver is approved. So, if na-approve ka based on the no objection statement and you are married to a US citizen at least 1 year before your initial 3-year validity or your 2-year extension expires. So, again, ito lang yun. So, anyway, you can actually go back to the presentation and review the slides, no? So, in terms of the timing, ito yung sagot ng tanong nyo. So, if you are in your 3rd year and you are subject to the 212E, but fortunately, you get approval of a waiver, then the best time to apply is while you are on your 2nd year. Or if you are already on your 4th year, then might as well apply once your 2-year extension is already been approved. And then, bibigyan ka nga, kung sa NOS ka nga, sa AVP ka nga nakakuha ng waiver mo, ito yung sinasabi natin na you will be required to spend 40 hours of training time to the beneficiary as designated by the AVP. So if you actually obtain a waiver through other means, it's either the BIE or exceptional hardship, and your employer would want to file the H-1B, the same issue, but you need to understand whether your school district is CAP exempt. If they are not CAP exempt, then it may take time for them to comply. Ang matagal kasi doon sa CAP exemption, so halimbawa you are in part of the public school system and hindi pa sila CAP exemption, the common issues that we actually see is it takes them time to have an affiliation agreement with a university or a college to have that formalities na, o sige, yung mga practice teacher or dual enrollment, normally yun yung mga common type of arrangement that they would want to have. Ngayon, if you are outside the US and you already have obtained, so ito yung sinasabi natin na, attorney, what if nasa ano na kami, nasa Pilipinas na kami, and then on our 6 months after we left the United States or 1 year after we left the United States, our waiver has been approved, then what can we do? Then call your US employer kasi pwede ka pa rin makabalik agad either on H-1B or kung meron na silang approved labor certification, they can apply for the green card for you. So I really hope that the two slides will be able to answer your question as to when is the best time to file for your H-1B or waiver, depending on what ground you are actually looking at. Elmer, so yung hardship waiver, kailang kasal ka sa US? Yeah, before you can apply for the exceptional hardship, you have either have a U.S. citizen child or you are married to a U.S. citizen or a green card holder spouse. Dips. Would it be possible that the school will start the processing? Again, it depends if you are subject to or not subject to. How about non-BIE but teaching large population? I answer that. Hello, how do you commute? Uh, how how do you commute the 2-year home residency requirement? So yeah, you how compute. Okay, how do you compute the 2-year home residency requirement? So the regulation actually says the aggregate of. So let's just say, no, natapos yung program mo, and then umuwi ka sa Philippines for 6 months, and then you get a job in Canada, then you stayed there for 1 year, and then babalik ka na naman sa Philippines, and you stayed there for 1 year and a half, then you already have complied your 2-year home residence requirement. So aggregate siya. Hindi naman siya kailangang straight 2 years. Pwede siyang putol-putol. You just have to add up the years na bumalik ka sa Philippines. Ang mga waiver po ba ay para lang sa nakapag-asawa or nagkaanak in the US or may 2 years citizen? Again, so then again, the no objection statement now doesn't seem to require the gusto ko mag-Tagalog para magkaintindihan tayo, no? But there are also other nationalities that is what who are actually watching the live. So again, the no objection statement doesn't require you in the Philippines it doesn't seem to require you now to have a U.S. citizen child or married to a U.S. citizen spouse or green card holder spouse. What they are actually asking now are meritorious projects or studies, and if you actually provide that, then they might consider your waiver application. The BIE doesn't require you to be married to a U.S. citizen or a green card holder or you have a U.S. citizen child. For as long as you are part of the BIE, within the BIE jurisdiction and your employer is willing to support your waiver, then you can apply for a waiver. It is only on exceptional hardship waivers that you are required to either be married to a U.S. citizen or a green card holder or you have a U.S. citizen's child. My question po is, paano po maka-work legally if nag-file ka ng hardship for your waiver, then nalaman ng visa sponsor and they cancel pwede bang mag-apply ng AAD while waiting for? So, the general rule is that you have to wait for your waiver to be approved before you file the green card. But to answer your question though, pag kinancel na yung J1 sponsor mo and you already have a pending green card application, then your immediate source of lawful, I mean, the legal basis to work legally speaking is your work permit. But that presumes that you already filed your green card application. I have a pahabol question. Pag mag-conduct ng training, research, same process lang ba kung paano mag-submit ng NOS sa AVP Philippines? So, I don't know if what you are referring to, kasi at one point kasi, the traditional way of applying for the no objection statement waiver through the ABP is sinasubmit talaga yon via mail, no? So again, if you are in the US, you're gonna submit it via FedEx or UPS. But then again, during the pandemic, they allowed applicants to submit via email. So scan copies lang yon. And then if you find reasons that your case deserve a second look, then they will ask you to submit more documentation. But based on their last year's guidelines, they seem to go back to the old procedure na kailangan mong email in yung application mo. Cesar, has the CFO provided guidelines on meritorious projects research yet? So again, I presume na late ka, Cesar, no? I said earlier that there is no specific guideline as to the projects or research. Ang sinabi lang nila that if you believe that your project or research seem to be meritorious or beneficial to the current priorities of the Philippine government, and since if you are a teacher, then you look into the priorities within the Department of Education, then might as well submit that. Maybe they will actually consider your proposal. Paano po if ang nasa BIE ay J2 dependent ko po? Paano po ang waiver through... okay. Paano po if ang nasa BIE ay ang J2 dependent ko? Paano ang so ang guidelines natin kanina, no, whatever the restriction on the J1 also applies to the J2, but I think I understand where you're coming from. The J2 cannot apply on their own unless they reach 21 years old. So then in that case, they could basically ask, they could still apply an IJA but not with the BIE. They could actually apply by asking the Department of State as the interested government agency. So, klaruhin ko lang ha, if your J2 is already 21 years old, and the J1 applicant is still in the United States, so they could actually ask the Department of State as the interested government agency para makapag-apply ng waiver yung J2 applicant. Eileen, follow-up question. So if it is not stated in the contract with the sponsor visa about marrying a US citizen, am I good to go? Wedding plan? Should be. Kung wala namang restriction doon sa contract mo. German, unsay maayo buhaton if dili ko subject na. So if you're not subject to the 212E and you are still within your initial 3 years, I would recommend that you talk to your employer if possibly they can transition to H1B. Uh, late pa ako. I understand. Thanks for addressing my question. Should I attach the proposal with the rest of? So, we don't assist no objection statement, and very simple lang naman ang procedure ng no objection statement. You can just visit the EBP website, Philippines, and just follow their procedure. It's very user-friendly and very clear naman. Going to fifth year na po kami, ano po ang the best na waiver na pwede namin ma-apply if ever po? So to answer the question, you really have to know ano bang meron ka, right? So if you are married to a US citizen or a green card holder or you have a US citizen child, maybe you can explore exceptional hardship. If you are part of the Bureau of Indian Education, maybe the BIA, IGA will be the best for you. If you have a good, if you are working on a very good project or research, maybe the NOS is best for you kasi mas mabilis sila. The J2 na sa BIA school po, makapag-apply po kaya siya. So again, the BIE IGA waiver, the J2 cannot apply on their own. But again, I would recommend, boss, that you consult because there might be a possibility to argue that, though the rule says the J2 applicant cannot apply on their own. If I'm gonna answer the question, there are two routes I would do. First, the IJA Department of State, and if again, this is the first time that I will be confronted with a J2 under the BIE. Paano ko ba sagutin to? In the BIE waiver application kasi, one of the factors that you need to prove is that you need to convince the Bureau of Indian Education that approving the waiver will be beneficial to the department or the Bureau of Indian Education, and that denying the waiver will be detrimental to the interests of the department as well. No? So in your case, if that is the case, then there is a way basically to comply with that arguments, but then you just have to reconcile that with the rule that, okay, the J1, the J2 cannot apply unless they are above 21 years old. And if they are, then they can apply the IJA through the Department of State. I would recommend that you consult with a lawyer then to see what's best for you. Last question, employee subject to the 212E. Pwede po bang mag-file ng green card process ang employer on the 4th? So, I subject to the 212E, you have no waiver, no green card, no H1. You have to go home. But the question is, can your employer, so let's just look into the possibility of, sige, uuwi na lang kami. No? Can the employer start the green card application? Definitely, right? Because again, the green card process, if they haven't started that, would take minimum 2 years. So even if you're going home, by the time that your 2 years is completed, then you are just waiting for your embassy interview. Then, you will be coming back as a green card holder or permanent resident instead of coming in back again on H, or again, don't take J1 anymore at that point. Okay, Jenny, what if J2 will be offered H1B because he is a nurse? Is it possible that the waiver will be waived for me on a J1? So it doesn't really talk about whether what profession you are. It actually talks about the rule. If you are subject to the 212E, you are subject to the, you need a waiver to be able to transition to the green card. But since you mentioned about the J2, then maybe the J2 will apply IJA through the Department of State and argue that nurses are needed in the US, and then argue your case. So to answer the question, what if a J will be offered H1B? Number one, nurses doesn't fall into H1B. So their only option is to go through the immigrant process or the green card process. But unlike the teachers, mas mabilis din yung pagpaprocess sa kanila, hindi siya 2 years. So again, I would recommend you consult with a lawyer to know what's best for you. But possible siya, no? Possible siya. 1 month before mag-expire ang H1B, nag-apply ako ng self-petition. Nag-apply din po ako ng B2 as recommended by a lawyer. After 5 months, umalis na kami sa US pero na-approve ang self-petition. Ang B2 approved na June but it was expired on the next day. Pwede po ba ako makabalik sa US? Di ba to reason to deny? Ma'am, I would recommend that you consult a lawyer. I know what you're talking about. When you actually do self-petition, are you talking about NIW? If you're talking about the national interest waiver, then I would recommend that you set up a consultation with us to know that. But to answer your question, if you left the US before na-approve yung B2 mo, then there is no unlawful presence. And then if you're, again, I don't know what self-petition means. It could mean anything, right? So if your self-petition will allow you to work in the United States on its own, then yes, makakabalik ka. Right? Kasi, halimbawa, NIW 01 would allow you to still work in the US, but until you apply for the green card application, yun doon ka i-confront about the waiver requirement. Wala po kami anak or asawa sa US citizen at 4th year, 5th year na po. IGA waiver po ba pwede? If you are part of the BIE, yes, you can. RJ, hopefully, attorney, you'll have a live on NIW 01. Yeah, definitely. But it may, I'm trying my best to do it this month, but sobrang busy lang talaga. No? Marami lang kasi nagtatanong talaga about waivers. That's why I'm putting in a presentation slide. So I think I'm on the last slide. I'm just finishing questions here, and then we're gonna complete the live session here. Kung may mga tanong pa kayo, again, I would recommend that write them down here. I could still stay 5-10 minutes just to answer specific questions because I'm already at the end of my presentation. Jan, J1 po ako under 212E. I am married to a US citizen. If I mag-apply ng spouse petition, will I most likely be approved? The spouse application will definitely be approved because ang inquiry lang naman ng spouse petition mo is whether or not the marriage is in good faith. Ang question mo is whether or not you could apply for the green card kasi subject ka sa 212E. In that case, I would recommend that you file for the exceptional hardship waiver because you are married to a US citizen. Or if you are under the BIE, then you might file for the IGA BIE. Randall, ang akin pong wife na J2 visa holder ay nagtuturo po sa isang school under BIE. Siya po ay pwedeng makakuha ng under BIE kasi kung pwede lang po ay hindi na siya umuwi. Again, boss, I would recommend no, kasi the rule kasi says that the J2 cannot apply on their own for the waiver. But then again, you could always challenge regulations, right? So I would recommend that you really consult a lawyer to look into the possibility of the J2 na lang ang mag-apply ng waiver or baka pwede siya mag-apply through the Department of State kasi mukhang maganda naman yung argument niya. Rosel, if you have already an approved J1 waiver, is it possible that you can apply for green card? Yes. So then again, if you're subject to, you can apply. This might be a reach out. Can a governor or a member of the House of Representatives apply for IGA? Alaska teachers. One of the factors that the first IGA case was approved because the senator, and the congressman was very helpful or very supportive of the effort of the school district to get their IGA waiver approved. So to answer the question, kung pwede ba ang governor ang mag-apply? No, it's not within the rules. But any support from the governor or the congressman or senator will be very helpful in the IGA waiver applications. Okay? So, again, wala na akong nakikitang unique na question about this. But I just want to actually say, para lang hindi pabalik-balik yung question. If you really would want to know yung specific answers to your question, if you could actually follow the YouTube channel kasi nga naka-subject matter naman yung videos or live, I would recommend doing that, or you follow the TikTok, or if you would want to actually send a message to iDream America 2. These are all my valid accounts. The Nicholas Caracal is my second account, but my staff have access to them. I don't recommend that you send a message to my personal account kasi napupuno talaga siya ng messages. So the chance of me missing some of the messages is most likely. So I would recommend that you send through iDream America kasi nababasa ko rin naman siya. So again, maraming salamat for joining me today, and I hope I was able to answer your questions related to the J1 waivers. Alam ko that's a very big concern for teachers who are already in the United States or who are actually coming to the US on a J1 visa. So this Facebook live is recorded. So it's recorded to several social media platforms, whether YouTube or Facebook. Then you could basically review them. Again, maraming salamat and enjoy your weekend. Bye-bye.